Additionally, I should point out that the understandings between President Carter and Panamanian leader Herrera, which were attached to the treaty and form part of the treaty, provide that the United States can, quote, defend the canal against any threat to the regime of neutrality. And I understand that as providing some degree of preemptive authority to intervene. One need not wait until the canal is actually closed by some act of sabotage or aggression, which, as we heard from the testimony, would be devastating to the United States. But there is some incipient ability to address potential violations.
And your final point there leads to my last question, which is, if the United States determines that Panama is in violation of the treaty, what is the range of remedies the United States would have for that treaty violation?
So I think it may be shocking to people to hear today, but when one goes over the ratification history and the debates and discussions in this body over this treaty, it was clear that the treaty was understood as giving both sides separately the right to resort to use armed force to enforce the provisions of the treaty. And it's not so surprising when one understands that the United States made an extraordinary concession to Panama by transferring this canal, which the United States built at great expense and maintained and operated, to Panama gratis. And in exchange, it received a kind of limitation, a permanent limitation on Panamanian sovereignty, that Panama agreed that the United States could enforce this regime of neutrality by force. Now, of course, armed force should never be the first recourse for any kind of international dispute and should not be arrived at sort of rashly or before negotiations and other kinds of good offices are exhausted. But it's quite clear that the treaty contemplates that as a remedy for violations.